Honorable Manya, over to you.
Yeah, thank you, Chairperson. Perhaps just to follow up from what Deputy President of the EFF, Commissar Floyd Shombo had said, just to follow up very quickly. Chairperson, firstly, I must express my serious disappointment in the manner in which the Reserve Bank has dealt with this matter. And the disappointment I have is that the Reserve Bank seems to have decidedly taken a narrowest of routes to deal with such an important matter, which has caused South Africa an international embarrassment on this matter, to have the whole president implicated in a situation where money is stuffed in sofas and mattresses is quite embarrassing, Chairperson. And for the Reserve Bank, given the milieu of regulations that the Reserve Bank operates under, for them just to pick one and leave the rest is really concerning, Chairperson. I'm very worried about how the Reserve Bank is conducting its work if this is what it's going to do. For instance, Chairperson, I want to bring to the attention of the Reserve Bank that there is something called financial sector regulation. There's a section there, section 15, subsection 1, which is very clear about what it is that the Reserve Bank needs to do. That section, Chairperson, compels the Reserve Bank to take all reasonable steps to prevent systemic events from occurring, and if systemic event has occurred or is imminent, to mitigate without delay the adverse effects of that systemic event on financial stability, and manage the system event and its effect. I want to argue, Chairperson, that the whole issue of 580,000 US dollars that have found its way into the shores of this country, and with all these wishy-washy explanations that we've been getting, that a systemic event has been triggered, as it were. And if you go to that financial sector regulation, Chairperson, they define the systemic event, and just and without, I'm not going to educate the Reserve Bank people, they know this better than me, but just for the benefit of even the media people now that are here, that a systemic event is defined in the Financial Sector Regulation Act as, I quote, any event or circumstances that may reasonably be expected to have a substantial adverse effect on the financial system, including an event or circumstances that leads to loss of confidence in the financial system. This is exactly what we have here. We have a situation where thousands of US dollars, if not millions, have entered into the country, and there seems to be no accountability anywhere. If you go to the customs and excise that the governor is pointing us to, they also tell us all kinds of things about confidentiality and all of that. And that is not taking us anywhere. Even the declaration statement that the SARS had issued, that declaration statement was a very ambiguous declaration that did not specifically deal with pala, did not specifically deal with the foreign currency in question. It simply just dealt globally with whether Ntabanyoni complied with the tax declarations and so on. And all of that can only be based on what Ntabanyoni would have declared. If Ntabanyoni kept that money in the sofa, it's not in the system, it's not in the bank, it's there's no way the Reserve, there's no way even the SARS would have known about this. But Chairperson, what's good about this in terms of the truth of the matter is that it's common cause that 580,000 at least of the millions that are there, at least this one is acknowledged. There are three sources that have acknowledged this money, that this money entered into the country. And the first one is the businessman himself, Mr. Hassim, has admitted to this. So we can tick a box. Where Mr. Ramaphosa himself has admitted to this, we can tick a box. The acting public protector is on record saying she has even received receipts as confirmation of the same. So that we have 580 in the country is a matter that all the affected parties have agreed to. The only people that don't seem to know about this are the authorities. SARS has not come out to confirm exactly how this money happened. The Reserve Bank, in fact, the explanation by the Reserve Bank today and following their statement is actually consistent with the letter that they'd written to the economic freedom fighters in August last year, where they said they have asked people from the presidency to give all kinds of information about this. So for us, the fact that they had to ask, it just meant that they don't have this. They don't have this money in their records, as it were, which is a concern. That's why they were asking for it. The Reserve Bank, we argue that they've got the most sophisticated systems. In a minute, the Reserve Bank should know or ought to know what money has come or has left the country. So the fact that they had to go asking the presidency people to say, give us information and all of that, it meant the Reserve Bank didn't know. Now, if today we're also told about imperfect transactions and all of that, is further confirmation that the Reserve Bank actually hasn't got the handle on what's happening with this money. They just hear everybody talking about it, but the Reserve Bank actually hasn't seen the money and all of that, which therefore we're worried that why is it that this whole issue is not concerning the Reserve Bank. We note, Chairperson, that the Reserve Bank doesn't seem to have an issue with the possession, and we never argued in any case about the possession. The issue is the duration of the possession. Let's draw the difference. Not the possession, the duration of the possession. That regulation 6.1, by the way, talks to the duration, as it were. Now we have a President Ramaphosa here that has kept the money for 45 days, and the Reserve Bank doesn't seem concerned about this. So the first question, Chairperson, is this: why is it that the fact that President Ramaphosa has kept the excessive amount of foreign currency beyond the 30 days, why for 45 days, which is beyond the allowable 30 days, why is it that the Reserve Bank is condoning that? I'm not interested, Chairperson, with the Reserve Bank telling us all kinds of things about the perfections of sales and what have you and all of that. I'm interested in the Reserve Bank that doesn't seem to be worried about a possible money laundering issue here. And the reason I want to introduce the money laundering issue here, Chairperson, is because we also have a report from a Section 89 panel, which was headed by no less than a former Chief Justice. The former Chief Justice has alluded to the fact that with the information in his disposal, he is of the view that there could very well be money laundering here. So therefore, why is it, Chairperson, that we have a Reserve Bank that is undermining the report of a former Chief Justice? And that report, by the way, is still standing. There hasn't been any structure. There hasn't been any court of law. There hasn't been any structure that has struck down that report. So that report still stands, as it were. President Ramaphosa tried to have it reviewed and then later changed their mind and all of that. And that report is therefore unchallenged. And that report states, therefore, that there were money laundering issues there. But the Reserve Bank has done absolutely nothing, Chairperson, to pursue the route of investigating money laundering. Now that all of these things are happening, this should all be telltale signs. How can it be that 2 or 3 years later, you have bought so many buffaloes, but you have not collected. In fact, there isn't no buffalo sale here. This is just money laundering. Why is the Reserve Bank not investigating this matter as a money laundering matter is my question. The next question, Chairperson, is this, that does the Reserve Bank, in fact, this is a question that Deputy President Floyd Shivambu has asked. I just want to repeat this question. Are they saying, is the Reserve Bank saying that you can go overseas or whatever and come back with a suitcase full of dollars, keep them in your trust? There's absolutely nothing wrong with that. Possession is okay. This is what the Reserve Bank is saying. I'm worried about this, Chairperson. I'm really worried about this because I'm worried about what this will do in the money laundering space. The Reserve Bank doesn't seem particularly worried with people that are hoarding all kinds of cash that is not in the financial system, and yet they are here supposed to be controlling the financial system. I'm worried about this, Chairperson. Lastly, I want, Chairperson, I must say this very slowly. I want to ask the Reserve Bank Governor to state under oath two things. One, that he can confirm to South Africa that there were no proceeds of crime. That the money that is there, that is confirmed, is not a proceed of crime. Can the Reserve Bank Governor go under oath and assure South Africa that there were no proceeds of crime, there was no money laundering or any of the sort? Can you go on under oath on that? Number one. Number two, shortly after this Phala shenanigan, we were greatly state as a country. Almost shortly after that, we would want to ask the Reserve Bank to again go under oath and confirm that the Phala scandal, those dollars have got no, have not been a factor in the grey listing of the country. Can the Reserve Bank confirm that under oath that is the case? Thank you, Chair. I think those are my questions.
Thanks, Honorable Manya. Dr. George.
Thank you, Chairperson. And thanks very much, Governor, for your presentation. The South African Reserve Bank lies at the heart of our financial system, and we must protect its integrity, and we must ensure that it is functioning effectively. Also, thank you, Governor, for your reply to my letter. It is appreciated. I have 5 questions. The first question. Section 33 of the Reserve Bank Act prohibits directors, officers, and employees of the bank from disclosing information, not the minister. So my question is, was the report made available to a minister, that means any minister, or the president? That is my first question. My second question, you mentioned that Mr. Hazim left the money as a security deposit. Where is the contract, and why was cash taken and not a bank guarantee? And who carried the risk of the dollars? That is my second question. And my third question, did the South African Reserve Bank consider how an entitlement can be contingent as envisaged in Regulation 6.5? And did the Reserve Bank consider the duty in Regulation 6.5 against delaying a contingency from eventuating? You did mention 6.1, but not 6.5. So that was my third question. My fourth question, is, did the South African Reserve Bank consider the impact its reasoning could have on money laundering and how persons can avoid declaring foreign currency by simply stipulating conditions in a contract? That is my fourth question. And then my final question. Has any action been taken previously against any individual or entity, even though a transaction had not been perfected? That is my fifth question. Thank you, Chair.
Thanks, Dr. George. Honorable Maswale.
Oh,
Thank you, Chair. Can I proceed?
Yes.
No, thank you very much, Chair. Thanks again from the Governor for the report. It would appear on the strength of the facts they have in their possession that there wasn't a transaction that was perfected. Well, you can live with that. Perhaps my question is related to perhaps the third part of Mr. George, Honorable George's questions in respect of the amount of money that exchanged hands between Mr. Ndlovu and Mr. Hasim. Pardon me if I'm not pronouncing or calling it appropriately. It would appear to me that would constitute a commencement of a process. However, that process was never concluded. In the light of what has transpired, I think the theft, etc., I'm not sure if it would be their call to make, but would it not be reasonable to then conclude that that exchange shouldn't have taken place? For it carried with it some implications, because foreign currency then exchanged hands and it was kept, and there is an obligation that ensues pursuant to acquiring a foreign currency. I'm just checking whether, with hindsight, it would have been inappropriate for that to have taken place, or perhaps it could have been represented in other forms, other instruments to constitute this intent to procure in the final analysis. I just don't know. I mean, given that then what transpired is what we read about, the theft as one of them, was it advisable, or would it have been the most appropriate, or what law then prevails in such a situation? Because certainly from somebody, a would-be purchaser and a would-be seller, they exchange money before the actual transaction is complete, in the sense. It does appear to me, relying on this latter part, conditions precedent, it shouldn't absolve treating that exchange in its specific circumstances. It's just a comment and question I'd like the Governor and the team to probably just fill in. It may help to clear the air so that there isn't a sense that could be construed to suggest that there could be other attempts to try and wash some of these underneath. Thank you, Chair.
Thanks, Honorable Maswale. Honorable Kganyago.
Chairperson, I detest it with passion generally when people come to us and they treat us like we're stupid. We are anything but stupid. For an example, this thing, the intention here is to, I don't know what, Bubsela or Chairperson, cloaked in regulations and nice English, but this is unadulterated claptrap, if you ask me. For an example, Dr. George is quite correct in saying, if you had experience of trading on the African continent, and other parts of the world, all you have to do is to provide a bank guarantee to show that you have enough money in your account to be able to take care of that transaction. The bank guarantee actually assures the seller of the product that you have the money and you're a serious buyer, right? You ask anyone who trades in petroleum, in the petroleum industry, in the sector, especially when it comes to the volumes of the amount of money that we're talking about, it's nonsense, or it's actually an insult. It's insulting our intelligence to say, because no bank guarantee was done, no formal processes were followed. Therefore, as the governor of the Reserve Bank is saying, it's okay for the money to be stuffed in the mattresses and whatnot. Usually when money is stuffed in mattresses because you're evading tax, it's money laundering, it's all the other issues that are illegal, of an illegal nature. You cannot hide money that is intended for legal transactions because you know you have tax liabilities. So to claim that it's okay because some people said some claptrap, which we can't prove. We can't prove it because there is the same Reserve Bank cannot make the report public. Then how do we test their rationale? How do we test their thinking around how the rationale behind the decisions they made? Secondly, their interpretation of the law, right? Because remember, the central bank is staffed with economists. They never agree on any issue. They always say on the other hand. It's the same applies to lawyers, for example. They would interpret different sections of legislation differently. And now we need to be able to have access to that report, apply our minds to it, and also have our legal teams actually looking into the report and agreeing whether or not their interpretation of these sections makes sense. What happens here, what seems to be happening here, I don't care about asking questions, Chairperson, because there's no need to ask questions. This whole thing is a whitewash. It's a cover-up. Is to say that we want to be able to actually, the president of the UDM wrote on the 22nd of August asking to have access to the report. And quite correctly, the Reserve Bank cited sections of legislations that make it impossible for them to release the report. But we are not dealing with just any Tom, Dick, and Harry. We're not dealing with Ngabom Zikwago and other people who are ordinary members of the public here. We're dealing with the head of state that stuffed money in so far as another hiding money, in essence, engaged in money laundering, if one were to look at the evidence around this issue, and kept the money beyond what is required in terms of the regulations, which is 30 days. And now we want to treat it like it's a normal, it's a normal what doesn't deal with the extent of the amount of money that was in the possession of the president, who in his right mind, Chairperson, would give you money before the transaction is perfected. If you were to consider just from a sales point of view, I have a sales background, it is the responsibility of the seller to make sure that everything else is done before the sale is perfected. Why? On what? Why? Am I stupid? Why would I give you my money, $500 for a sales that is yet to be perfected, even if you were to follow it legally? You must first follow the steps, make sure that all the steps are followed, before I pay you the deposit. Otherwise, what am I paying you the deposit for? Are we stupid? We can't pay you the deposit if you have not met the conditions are the responsibility of the seller and not the responsibility of the person who brought in the money. And we're not answering the critical question, how did the money come into the country? And is it okay, really? I think the question which was asked by Honorable Shivambu earlier, and which later was also asked by Honorable Manyi, is that is it okay for people to keep money for as long as they want? Because then it means that it will depend on between me and the seller to determine as to when I can disclose the funds. Then what is the purpose of the law? It renders the whole legal framework and the regulatory framework that we have in place useless. If it's then going to be up to the members of the public to determine as to when they can disclose when they're in possession of the foreign currency, I can take 5 years, I can take 10 years, I can take 10 to 20 years, because the conditions will always be industry specific. But the law should actually look at the median, would look at the average, the middle, to say what is reasonable in terms of disclosure. We can't leave it up to Cyril Ramaphosa, the president of the republic, and the other chap who came to the country with foreign currency, and we don't even know how he came into the country with this foreign currency. We don't even know why the money was kept for such a long period without it being disclosed. But the worst part of it, which annoys a great deal out of me, it really drives me out the wall, is that The Reserve Bank says we've conducted an investigation, but we can't test the application of the law. We can't test the rationale behind the decisions that have been made. We can't say anything. In fact, we have applied for PIA primarily because of the response they gave to us, because we want to be able to test their reasoning. We want to be able to test the application of the law. Without that, it means we're living in a banana republic. And you see how the Reserve Bank has actually dealt with this thing. Actually dents its reputation to a large extent. You might disagree with the Reserve Bank from an ideological point of view and a policy point of view, but they've done relatively well. But on this thing, they've been dismal, I must be honest. And the last issue is, when it comes to ordinary South Africans, and how authorities deal with money laundering issues or allegations against them. I know people whose accounts have been frozen because of simple allegations or thought that they might be engaging in money laundering. But it's easy for people because some are more equal before the law. It's easy for them to get away with this issue. It's easy for us to actually say, no, abdicate responsibility to other institutions and say, this should have been done elsewhere, right? But what is the point then of doing a comprehensive investigation on this particular question? If an institution that is as credible, if it was not as credible and reputable as the Reserve Bank, can abdicate responsibility and say, we don't care how the money came into this country, and yet they are here for financial regulation issues and to ensure price stability, but they don't care about how the money came into the country. They did not actually even inquire as to how the money came into the country, why it was kept in the sofas. The only thing there is a legal nicety of saying, technically, was the transaction perfected? It means other sectors of our economy can say, it takes actually 15 years to perfect a transaction for us. And that is how long the Reserve Bank must wait before we can be able to declare. It's nonsense. The law is supposed to create minimum standards for everyone to comply with. If they don't comply with that, they are supposed to answer. Now we hear that it's 18 months, it's however long those two contracting parties can decide. What kind of country enters into that, where we depend on the contracting parties and there are no minimum requirements? It's claptrap. We're being made stupid. And I hate it when people appear before Parliament and they pretend as if we don't have gray matter in our heads. Actually, we know what we're talking about. Thank you.